Namaste students, I am Professor Dr. Veena Diwan, Director Faculty of Land Governance from Jayoti Vidyapeeth Women's University, Jaipur. I hope all of you are safe. So, let me start today's our session. Today's our session is essential conditions for Muslim marriage in India. What are the essential conditions of Muslim marriage in India? Marriage or nikah under Muslim law bears much resemblance to a civil contract. Its essential conditions involved. मैंने आपको पहले भी बताया था कि निकाह मुस्लिम मैरिज जिसका निकाह भी नाम है ये बिल्कुल किससे रिजेंबल करता है? लाइक सिविल कॉन्ट्रैक्ट की तरह. क्या क्या एसेंशियल कंडीशंस हैं? राइट डाउन. नंबर 1, अ क्लियर ऑफर, जिस तरीके से कॉन्ट्रैक्ट में होता है. A clear offer and acceptance which must be given in the same meeting. A consideration from the husband side to the wife known as meher between parties competent to contract. Islam as a religion or even those devoted to similar scriptures in the Sunni sect. This is subject to certain prohibition under the law, such as bar to marriage during the period of iddat, bar by consanguinity, bar by affinity. Clear? Second condition, essential conditions for Muslim marriage: offer and acceptance. It has been observed by the court in the case, write down, Abdul Qadir versus Salima and others, that a Muslim marriage is in the form of a civil contract, and therefore the concept of offer and acceptance applies to a Muslim marriage just like a civil contract. An offer is called ijab in Muslim law, and an acceptance is called Kaboom. The offer is made by the husband. It can be either made by the man or a person who has been authorized by the man. Now, since a Muslim marriage is a contract, it is allowed to have certain preconditions to the marriage and on the fulfillment of the same. The marriage can be accepted by both the parties. It further needs to be ascertained that these terms and conditions should be in consonance with legal principles and public policy. Clear? What also needs to be understood is that these terms and conditions are to ensure that the rights of the woman in the marriage are safeguarded. Because so students, because in Muslim marriage, the man has the right to divorce the woman by way of talaq, which is vital in effect that a Muslim woman's right to divorce called khula. The instant talaq by way of uttering the word or the talaq biddat has now been invalidated by the Honorable Supreme Court in the triple talaq case. The acceptance needs to be carried out in a way where the man or someone on his behalf and the woman is someone on her behalf needs to give their acceptance to the marriage. This needs to be taken in the presence of at least one male and two female witnesses who should be adult, same Mohammedan. The Shia sect of Muslim does not mandatorily require the norm of witness and it can be done away with. Moreover, if there is no witness to the marriage, it becomes a more irregularity and not invalidation. Moreover, acceptance can also be made by way of accepting the dower. Once the man offers the dower to the woman and she accepts the same, it means that the marriage is accepted. Clear? An important condition regarding the offer and acceptance is that both must occur in the same meeting. Also, the offer of marriage should begin the marriage immediately. That is, an offer of marrying someone the next month is not a valid offer. Understood? थर्ड, कंसिडरेशन. ये सेम वही पॉइंट्स है जो एक कॉन्ट्रैक्ट के लिए जरूरी होते हैं, क्योंकि यहाँ मैरिज भी एक तरह से सिविल कॉन्ट्रैक्ट है, तो वही कंडीशंस, वही एसेंशियल कंडीशंस जो कॉन्ट्रैक्ट में अप्लाई हो रही थी वो यहाँ भी अप्लाई होती है. कंसिडरेशन अंडर कॉन्ट्रैक्ट लॉ simply means something for something. Hence, it is constitutes in a Muslim marriage that the woman must receive as a matter of right a sum of money from the husband's side called meher or dower. According to the Prophet, this dower is a form of honor and respect given to a woman when she agrees to marry a man by way of accepting the dower. The practical purpose is to assure the financial security of the woman in and after marriage. Clear? The right to the dower of a woman can be exerted before cohabitation. The Allahabad High Court has said the case the Nasra Begum versus Rizwan Ali का, उस केस में इलाहाबाद हाई कोर्ट ने क्या कहा कि दैट अ वुमेन्स फैमिली कैन रिफ्यूज टू सेंड हर टू हर मैट्रिमोनियल होम इफ डॉवर इज नॉट गिवन. वंस द डॉवर इज एक्सेप्टेड बाय द वुमेन, शी इज रिटर्न एग्री टू मैरी द मैन. देयरफॉर द कॉन्ट्रैक्ट इज कंप्लीट. द कॉन्ट्रैक्ट इज हाउएवर subject to the following conditions are prohibitions. Next, competency of parties. Two factors decide the competency of parties to enter into a marriage under Muslim law: the age and soundness of mind. Once the girl and boy have attained puberty, they become competent to be a party to the institution of marriage. This also means that when the girl and the boy are sexually competent to consummate a marriage, they are allowed. Now, since it is based on physical and emotional features, it becomes difficult to ascertain the exact age at which it would be a valid marriage. Throughout the history, the usual age is 9 for a girl and 12 for a boy. With the passage of time, the Privy Council in the case Muhammad Ibrahim versus Atikia Begum and others has set the maximum age at 15 years, and this age applies to both the man and the woman. The Privy Councils gave two conditions. Number 1, attainment of the age of 15 years of the woman, attainment of puberty, whichever is earlier. And once puberty is attained, the power of authorization either by itself or to whoever is accepting on their behalf arises. The other consideration is soundness of mind. where it must be seen whether it is a case of idiocy, that is consistent and permanent unsoundness, or lunacy, that is acquired unsoundness with periods of sanity. Sanity between the former is entirely incompetent to contract, but the later may marry by giving consent in the period of sanity. In case of a minor or a lunatic person who is not capable to authorize, then the power of guardian, parents, and family can be regarded. The offer and acceptance on their behalf can be given by the guardian. The guardian who are allowed to authorize the marriage of a minor are कौन? The father, write down, the father. Second, the paternal grandfather or anyone higher. Third, brother. Fourth, mother. Fifth, maternal uncle or aunt or someone from the family. This is the hierarchy which needs to be adhered to when the marriage of a minor comes into question. But when none of the guardian mentioned about is there, then a quasi or any government authority, then a kaji or any government authority can assume the position of a guardian in case of a minor child. समझ में आ गया? The religion of the parties. In Muslim law, the religion of the parties plays a vital role, since the marriage will be governed by a Muslim law. It needs to be given a certain status. However, the rules and sunnah, मतलब traditions, differ in the communities of Sunni Muslim and Shia Muslims. Sunni law, write down. In the case of the Sunni sect, when a man marries a woman from another sect, for example, if Sunni man marries a Shia woman, if a Sunni man marries a Shia woman, then such a marriage is purely an intersect marriage. Such marriages are perfectly valid. However, there is a difference when a woman is a Christian or a Jew. These are called the Kitabiya communities. The word Kitabiya is derived from the word Kitab, which means book. When there is a marriage which is between a Muslim and a Kitabiya, then such marriages are allowed and are valid as well. However, if the woman is non-Muslim and also does not belong to the Kitabiya community, then the marriage is fasid. This means the man has either married a Hindu or a non-Muslim, not from the Kitabiya community. Such marriages are irregular, though they are not valid. This irregularity can also be done away with if the woman converted into a Muslim woman. Therefore, the irregularity is removed and the marriage automatically becomes a valid marriage. Second, Shia law. Shia law is very conservative as compared to the Sunni law. The Shia man traditionally can only marry a Muslim girl. Yes, this would include intersex marriage. मतलब a Shia man can marry a Sunni woman as long as she is Muslim. However, unlike Sunni law, a Shia man cannot marry a Kitabi or a Hindu girl, and if such marriage takes place, then it is automatically becomes void in Muslim law. However, if the girl converts into a Muslim, the deformity can be removed. Shia law allows mutta marriage. A mutta marriage is one which is temporary marriage or for a limited period of time. Traditionally, such marriage could be solemnized when the man in the marriage was traveling for long distances. In that case, mutta marriage could be performed to validate a marriage between a Shia man and a non-Muslim woman. Certain prohibitions to marriage during iddat. Iddat is a time period after the divorce or death of the husband in which the wife is not allowed to marry anyone else. The purpose behind this is to see whether the woman remains pregnant with that husband's child or not. So as to avoid any doubts regarding parentage, the period is 3 months in case of divorce and 4 lunar month and 10 days in case of death. समझ में आया? The status of marriage entered into during iddat differ in case the Sunni and Shia sects of Muslims. The Sunni men are not allowed to marry during the iddat period. However, if they do well, the marriage shall assume the status of a mere irregularity and the validity of such a marriage can't really be questioned. What this means? The marriage will be deemed as invalid till the irregularity. That is, till the period of iddat exists and upon its end the irregularity will be removed and the marriage will become valid. On the other hand, in the Shia sect, men are prohibited to marry during the iddat period. If a man does so, then such a marriage is considered void. Disability cannot be removed. Consanguinity. Marriage between people within the prohibited degree of blood relation is banned in a Muslim law as well. This means that marriage between people in blood relation up to certain number of generation is invalid. Like a man cannot marry his mother, grandmother, daughter, sister, niece, etc. Affinity. Some other relationships are also considered void based on the closeness of the relationship. Like a man cannot marry his wife's grandmother. Similarly, relationship based on fosterage are also barred to some extent. A man can't marry one's foster grandmother or foster sister. Under Sunni law, some relationships in fosterage are allowed. In Shia sect, fosterage and consanguinity are on the same pedestal and both render a marriage invalid. So students, today our session is completed. I tell you some important questions which will be beneficiary for examination purpose. So write down in your notebooks what are the essential conditions for a Muslim marriage. Explain the valid conditions for a valid Muslim marriage with decided case laws. Students, if you have any doubt, any query, you can feel free to contact me. Thank you. Thank you for listening to me.